Hello guys and welcome back to another video in the environmental law series, and in this video we are going to look into various cases with regards to the environmental law. I have also put timestamps in the description as well as the pinned comment of this video. So let's get started. Let's first look into the case of Municipal Council Ratlam versus Sri Vardi Chand and others. This case took place in the city of Ratlam in the state of Madhya Pradesh. Some of the residents of the municipality, in this case, filed the complaint before a sub-divisional magistrate. The complaint was filed because the residents believed that there was no proper drainage construction, and due to this the streets were stinking horribly. On listening to the arguments, the sub-divisional magistrate instructed the municipality to prepare a proper form of developed plan with regards to the drainage system. And told the municipality to do it within 6 months. The municipality then stated that firstly that they do not have financial support, and secondly that they do not have proper funds to comply with the directions which were given by the sub-divisional magistrate. The residents further argued that the municipality of Ratlam city has failed to meet the obligation even after the direction given by the sub-divisional magistrate. And furthermore has failed to provide for the public health, including by failing to abate pollution and other hazardous waste from impacting their homes. The responder further focused to stop pollution caused by a runoff from a nearby alcohol plant, resulting in a form of malaria. When the case reached the Supreme Court instructed the municipality to protect the area from pollution and also pollution caused by the alcohol plant following into the neighboring areas of the resident. The Supreme Court also ordered the municipal to take necessary steps to fulfill the obligation by providing adequate number of public laterals for specifically men as well as separately for women, along with proper water supply in the morning as well as in the evening. The court also ordered this obligation to be fulfilled within 6 months from the court's order. It was held by the Supreme Court that the pollution-free environment is an integral part of the right to life under Article 21. Let's look into the next case of MC Mehta versus Union of India. This case was regards to disposing of the effluent from the leather industries in the Ganga River. So a writ petition was filed by MC Mehta in 1985. This petition was to restrain the respondent from releasing effluents into Ganga River. The court in this case highlighted the fact that if we look into a constitutional framework, it highly enshrines the fact that we need to protect our environment. Moreover, if we look into the Article 48A, it provides that we as a citizen should endeavor to protect and improve the environment, and safeguard forest and wildlife of the country. Furthermore, if we look into Article 51A, it provides that the Constitution of India has a fundamental duty as a citizen to protect the forests, lakes, rivers and wildlife. So court in this case held that just like an industry which cannot pay minimum wage to its workers, tannery which cannot set up a primary treatment plant cannot be allowed to exist. Let's look into the next case of Andhra Pradesh Pollution Control Board versus Professor M.V. Naidu and others. This case was with regards to establishing a new factory for the production of vegetable oil in the state of Andhra Pradesh. The respondent in this case had purchased a land in Indore village naming Pedashpur. The question in this case was with regards to the validity of exemption granted for the operation of the 10-kilometer rule. Now, what is this 10-kilometer rule? Now, this 10-kilometer rule by the government of India is qualified to be as the eco-sensitive zone. So whenever there is any sort of clearance project, it should be made sure that clearance of a project required is within the 10-kilometer of the National Park Wildlife Sanctuary. So the Supreme Court in this case relied on the judicial doctrine of precautionary principle. Okay, the precautionary principle, as it is very name suggests, needs the authority in charge to anticipate, prevent and attack the reason behind the environmental pollution. Now next, let's look into the case of Rural Litigation and Entitlement Kendra and others versus State of Uttar Pradesh and others. So in this case, quarrying activity was being carried out in the Mussoorie Hill range of Himalayas. Okay. Now, furthermore, limestone was extracted by blasting out the hills with dynamite. Okay, this practice is absolutely illegal. Due to lack of vegetation, many landslides occurred, and which has killed many villagers, including destroying their home, cattle and agricultural land. So initially the mining operators argued the fact that the case needs to be dismissed because of the lack of jurisdiction. But the court rejected the miners' argument and moved on with the case anyway. Later on, a committee was set up. This was the monitoring committee. The monitoring committee directed the mining company, certain ways, scientific ways to continue with the quarrying of limestone. But the mining company, continued with their unscientific methods and hence did not comply with the instructions given by the monitoring company. In an application filed by the committee, the court held that the mining activity secretly carried out by this company has caused immense damage to the environment and thus had directed to pay the fine of 3 lakhs to the fund of the monitoring committee. After years, the Supreme Court of India held that the pollution caused by quarrying adversely affects the health and safety of the people and hence same should be stopped. The right to wholesome environment is a part of right to life and hence the personal liberty guaranteed under the Article 21 of the Constitution. The court in this case directed to first of all terminate all the mining activities. Secondly, to look into new areas to do the limestone mining. Okay, it also ordered that the Eco Task Force of the Central Department of Environment reclaim and reforest the area damaged by mining, and that the workers displaced by the mine closure be given priority for jobs with the Eco Task Force operation in the region. Next, let's look into case of Sachidhanan Pandey versus State of West Bengal. In this case, it was observed that the court is obliged to carry in the mind before the Article 48A and 51AG whenever a case is linked to environmental difficulty. Okay, so it is said that the court must refer to these articles, Article 48A and Article 51AG, whenever a case is with regards to the environmental difficulty or environmental law. Let's look into the case of Valere Citizen Welfare Forum versus Union of India. In this case, a petition was filed due to excessive pollution which was caused by tanneries and the effluents were disposed in the river Palar. Okay, this river Palar was considered to be as the important source of drinking as well as bathing for the people of the surrounding villages. Okay, later in further research, the Tamil Nadu Agricultural University Research Center Vellore discovered the fact that approximately 35,000 hectares of agricultural land has been partially or entirely unsuitable for cultivation due to the same. This particular case is considered to be one of the most landmark cases, okay, because it analyzes this relationship between the environment and the industrial development. Okay, so in this case, the court conveyed its judgment in the favor of the petitioner and guided all the tanneries to submit a whole of rupees 10,000 as a fine to collector's office. Okay, the court also further coordinated with the state of Tamil Nadu and granted Mr. M.C. Mehta with the entirety of rupees 50,000 as gratefulness towards his endeavor to security of the environment. Now let's look into the case of Damodar Rao versus SO Municipal Corporation. In this case, the court held that the environmental pollution and spoliation which is slowly poisoning and polluting the atmosphere should be regarded as amounting to violation of Article 21 of the Indian Constitution. In the next case of K.M. Chennappa Godavarnam versus Union of India. In this case, the petitioner had challenged the continuation of open cast mining by the public sector corporation in the heart of a national park. Mining has resulted in large-scale destruction in the Bhadra river system, on which the millions of farmers are dependent on for their livelihood. Hence, the Supreme Court decided to set up a compensatory afforestation fund management and planning authority to monitor the afforestation efforts, to oversee the compensation who suffered on the account of deforestation, and to accelerate activity for preservation of natural forests. Next, let's look into the case of MC Mehta versus Union of India, gas leak in the Shriram factory. In this case, there was a leakage of poisonous gas from the Union Carbide Corporation India Limited. This disaster is considered to be as the world's worst industrial disaster, and it claimed more than thousands lives and lakhs of injuries. When the matter was pending before the Supreme Court, another disaster took place in the Shriram food and fertilizer industry. MC Mehta thus filed a public interest litigation petition under Article 32 of the Constitution. Okay, and thus in this case Chief Justice Mr. P.M. Bhagwati evolved the rule of absolute liability. Court held that the absolute liability of a hazardous chemical manufacturer to give compensation to all affected by accident was introduced in this case, and it was the first time that the compensation was paid to the victim. Furthermore, the court laid down the following principles. The management of the Shriram Food was required to deposit 20 lakhs in the court as the security for the payment of compensation to the victim. Okay, a green belt of 1 to 5 kilometers within such industry should be provided. The court directed the central government to set up environmental court consisting of judge and two experts who are experts in the field of ecological science research. The court also recommended the Government of India to pass the National Environment Tribunal Act 1995 to deal with the cases of the environmental pollution. Now next, let's look into the case of Indian Council for Enviro Legal Action versus Union of India. In this case, the court held that the financial cost of preventing or remedying damage caused by the pollution should lie with the undertaking which causes the pollution, adopting the polluter pay principle. Then furthermore, in the case of Tarun Bharat Sangh versus Union of India, a petition was filed by Tarun Bharat Sangh in the Supreme Court to stop mining activities in the Sariska Wildlife Sanctuary. Okay, the court held that all the mining activities should be banned in the sanctuary. Next, in the case of MC Mehta versus Union of India 1987, this case was also known as the Taj Trapezium case. Okay, in this case, the historical judgment was given with regards to various directions, including banning of use of coal and directing the industry to use the compressed natural gas or CNG. Next, the case of Miss Betty C. Alvarez versus State of Goa and others. In this case, a complaint was filed for illegal construction in the coastal regulation zone of Kandolim, Goa. Okay, the complaint was made by a foreign national. The objection which was raised in this case was the fact that Betty Alvarez was not an Indian national and thus legally incompetent to file the petition under Article 21 because she was a non-citizen and she does not have any rights guaranteed under the Indian Constitution. Okay, the case was initially under the High Court of Bombay and then transferred to the National Green Tribunal. The court in this case maintained the fact that Betty Alvarez is still allowed to file this application even though she is not the citizen of India. Therefore, Miss Betty's application was maintainable without regards to the question of her nationality. Next, let's look into the case of MC Mehta versus Kamal Nath and others. The Indian Express published an article article reporting a private company has a floated ambitious project called as Span Club. Kamal Nath, who was a Minister of Environment and Forest, had direct link to this company. A large acre of land, which included forest land, was leased out to the company. The court quashed the lease deed by which the forest land was leased to the motel company and held that the construction activity out by the motel company was not justified. The motel was also ordered to pay compensation by the way of cost for the restitution of environmental and ecology of the area. The motel was further ordered to construct boundary wall at the distance of not more than 4 meters for the building of the motel, beyond which they are not allowed to use the land of the river basin. Hence, the public trust doctrine was applied. Next, let's look into the case of Animal Welfare Board of India versus A. Nagaraj and others. In this case, the court looked into the section 3 and section 11 of the Prevention of Cruelty to Animal Act of 1960 and declared that animal fights incited by human are illegal, even though those are carried out under the guise of tradition and culture. The court listed various recommendations and penalties, including punishment in the Prevention of Cruelty to Animal Act 1960 to function effectively. Next, let's move on to the incident in front of the National Green Tribunal in the matter of Art of Living case on Yamuna flood plains. In this case, the National Green Tribunal held that the Art of Living Foundation, responsible for the alleged damage caused to the Yamuna flood plains due to the World Cultural Festival organized in March of 2016. The tribunal found that the organizers of the festival violated environmental norms and severely damaged the floodplain area at the bank of the Yamuna river in Delhi. The tribunal was imposed the fine of 5 crores as the environmental compensation, which has come down heavily on the foundation and for not disclosing the full plan. The panel also warned the foundation that in case of the failure of payment, the further penalization amount will be 2.5 crores, which the Ministry of the Culture is supposed to pay to the foundation, will be attached. While reacting to the dismay of the verdict, the foundation expressed disappointment and claimed that they had complied with all the norms and the submissions were not considered by the tribunal. The foundation further has expressed the fact that they will appeal to the Supreme Court. Next, let's look into the case of Almitra H. Patel and others versus Union of India and others. This case is the biggest case which has dealt with the solid waste management in India. In this case, Mrs. Patel and others filed a public interest litigation under Article 32 of the Indian Constitution, wherein the petitioner sought immediate relief and improvement in the practices with regards to the municipal solid waste or garbage and the way it is treated in India. The tribunal therefore asked all the states and the union territories to strictly follow and implement the Solid Management Rules 2016. A complete prohibition on the open burning of the waste on land was made after this case. Next, let's look into the case of Subhash Kumar versus State of Bihar and others. In this case, the petition was filed by the way of public interest litigation by Subhash Kumar for preventing pollution on the river Garo from the discharge of the slurry from the Tata Iron and Steel Company Limited. The Apex Court held that the right to get pollution-free water and air is a fundamental right under Article 21. Next, let's look into the case of Save Mon Region Federation and others versus Union of India and others. The federation, on behalf of the indigenous community, challenged the environmental clearance grant for the construction of hydroelectric dam on the Nyamjangchu River. The federation pointed out faults in the environmental impact assessment procedure and the lack of scrutiny of the project by the experts of the community. National Green Tribunal concluded that it is true that the hydropower project provides eco-friendly renewable resource of energy and its development is necessary. However, we are of the considered view that such development projects should be sustainable development without there being any irretrievable loss of life to the environment. Next, let's look into the case of Samit Mehta versus Union of India and others. This case was filed due to the damage caused by the sinking of a ship which was carrying coal, fuel oil and diesel. Due to the sinking of this ship, a thick layer of oil was formed on the surface of sea which caused damage to the marine ecosystem. In this case, the court evolved the principle of the polluter's pay. The tribunal further held that it has a power to grant compensation for the cost incurred by the central government to clean the wreck, which may pose hazards to the navigation and marine environment. Next, let's look into the case of MC Mehta versus Union of India. This is also known as the vehicular pollution case. There was a writ petition filed by MC Mehta requesting the court to pass appropriate orders for reduction of the vehicular pollution in Delhi. Supreme Court in this case held that Indian Constitution recognizes the importance of protecting of environment, life, flora, fauna by virtue of Article 51A and directive principle of the state policy. The committee was set up which has given the following objectives. Okay, to make an assessment of technologies available for vehicular pollution control in the world, to make assessment of the current status of technology available in India for controlling vehicular pollution, to look at the low cost alternative for operating vehicles at reduced pollution level in the metropolitan cities of India, to examine the feasibility of measures to reduce or eliminate pollution from motor vehicles both on short term and long term basis and make appropriate recommendation in this regard. And lastly, to make specific recommendation on the administrative or legal regulation required for implementing the recommendation. The committee was ordered to give report in 2 months and also mention the steps taken. So that's all for today's video guys. I'll see you in the next video. Take care.